Hello all, here we go, the first video class session. Classes, there are a lot of video class sessions which has been uploaded in the YouTube. This time it's a little bit topic wise session, so that it will be very useful for you, and I have my own controls here to adjust. So it's better you use a good headphone and compromise with the video quality, and you give the feedbacks so that any improvement will be made in the subsequent topics. Coming to today's topic, we'll be dealing with related party transactions. As you all know, it is comparatively an important topic for CA final, and you have your own accounting standard to deal with that also, so you have to keep in mind that also. Section 188 deals with related party transactions, and we have to refer some rules also. We will be dealing with the same. Yes, disclaimer clause, of course. Coming to the topic, what is a related party transaction? Meaning of related party transaction. Any transaction by a company, one side, and the related party to the company in the other side is called as a related party transaction. I'll repeat again, you have two sides of a transaction, right? Any transaction you require two parties. One here is the company, and second one is persons who are related to companies. So that's why the definition goes like this: any transaction by a company, right, with a related party to the company is commonly called as related party transaction. So two sides, one is the company, for example, a contract has been entered by a company with X, but this X is related to the company. We will see what is that relation in soon. I like to advise you to refer to the accounting standard applicable to the related party disclosures. I think the relevant one in AS 24, and earlier it was AS 18. So this is the meaning of related party. Any company in its course of business used to enter into transactions with parties which is related to the company. So that is why the law makes some disclosures, some approval systems for that. Now, coming to the slides moving in, is the key question here is who is a related party. Related party is defined in section 2 clause 76 to clause 76 to mean a director of the company or his relative. So one side I told you company, the other side is now a director of that company or the relative of that director. We are talking about, I told you, we are talking about two sides. One is X and next one is Y. For example, Y. We are now discussing about Y. Y is defined under 2 clause 76. X is the company in our example. Y is related parties which are talking. What are the related parties? The section starts with the director of the company or his relative. Second category is the KMB of the company or his relative. For example, if you are a CFO of a company, any transaction by the company with you, any transaction means the listed transaction by the company with you will be called as a related party transaction. Third category is the firm in which the director, manager, the relative is a partner, of course. And fourth is a private limited company in which the director or manager is a member or director. So there is a private limited company on the other side. The company is going to enter into a contract with that private company. But the issue is our company's director is a member or director of that company. So that means that private limited company will become a related party to this company. I am not going to the very intricacies of the things due to the time constraint, and you have to refer that. But at the same time, you must understand the conceptual clarity with regard to the related party transfer. One side company, the second side in this slide is we are saying is a director or director's relative or the KMB of the company or his relative. A firm in which the director is a partner, a private limited company in which the director is a partner or member, and that the story goes like that. And the list continues. Earlier we told private limited company, now we are talking about a public limited company in which the director or along with other directors hold 2%. So this is a law point, you must understand there is a limit here. In the case of public limited company, that public limited company will become a related party to the company only if our director is also a director of that company, that public limited company. But for attracting this clause, the director along with his relatives, along with other directors, should minimum hold 2% of the paid capital of that public limited company. Now goes the big one where a practical question can be asked. We told about the director, we told about the relative of the director. we told about the firm, we told about private limited company, we told about public limited company. Now the big show is about any body corporate. See the word any body corporate whose board, whose MD, whose manager, whose board, whose managing director, whose manager is accustomed to act. Who is accustomed to act? Our director, our company is having the power to control any body corporate or its board, its MD or its manager. That is the point, or its manager. And with that control, a relation is been created. That is the law says. So I will list down. We told about a director, his relative, KMB, right? A private limited company, a firm, a public limited company, but ultimately a body corporate in which that body corporate's board, that body corporate's MD or manager is accustomed to act as per the direction of us. So that means that entity, that body corporate is a related party for us. So these are the things which is very intricately how to look into. So students, I move further, and there is an exemption which is very important. Provided that nothing in this subclauses one's clauses, any direction, advice, instruction given given in a professional capacity is exempted. So this is again a practical thing. We told any body corporate, any MD, any director who is accustomed to act. What is accustomed to act? We are giving an instruction. He have to comply with that. We are giving an advice. He have to comply with that. But this advice, this instructions, etc., will not be covered in the case you are giving such advice in your professional capacity. For example, you are a statute auditor, or you are a KMB, or you are a company secretary of a company. This A company is going to give directions to a body corporate. As per the law, if that body corporate is accustomed to act as per my company secretary's advice, then there is a related party transaction. Now what the law says, I am advising them not in the capacity of being accustomed to act, but I am advising them because I am in a professional capacity. For example, regarding a bonus issue, regarding CSR funding, I am giving a written advice to them. Whether they have to comply, they will be accustomed because they are accustomed to act. But that is not covered under 188 because I am giving that advice only in the professional capacity. So section 2 clause 76 is the next thing which we discussed earlier. You have to study that in thoroughly, and I will go through it once again. Just 276, we have 3 slides for that. You have to study it thoroughly. Now we will move on to the area called which transactions are. I am saying frequently about related party transaction. Now a doubt which will create in your mind is, sir, what are the transactions covered? Most of the transactions are covered. If you see the list which is given under section 188 of the Companies Act, most of the transactions covered. If you compare with the 1956 Act, you can see some practical questions in the books. In 1956 Act, transactions relating to immovable property was exempted. But in the new law, in 2013, that is section 188, if you see, most of the transactions are covered. So all transactions, say, I will list out it: sale, purchase, supply of goods or material. That means everything is covered: sale, purchase, supply. Then buying, selling, disposing of property of any kind. See the word any kind. That means comes movable property, immobile property, intellectual property, intangible property. So that means by the version of the word, by the interpreting the word any transactions, it is clear that all the transactions for movable properties, for immobile properties, including intangible properties like patent, copyright transfer, assignment of patent, assignment of copyright transactions, giving assigning the patent of a company to a body corporate, to a firm in which our director is interested, clearly comes under the related party transactions. The transaction list goes on again. You have to study it very well in your home. Availing or rendering of any service, that means advertising service, advisory service, appointment of agent, related party, again, underwriting transactions. So I don't want to list it in the video class. You have to thoroughly, intimately, you have to study the list of transactions, and you will understand one thing, that most of the transactions are covered without exemptions. So that is the list of transactions. So what were the method which we have been learning? First I told about what is a related party transaction. Then I told about 2 clause 76 who is related party. Then I told about what are the a list of related party. Then we discussed about what are the transactions. Now we will move on. Coming to exemption transaction. See, there are some exemptions which is given to the related party transactions. As you know, the transactions in the arm's length price. CA students are well knowing about transfer pricing, arm's length, etc. etc. Arm's length basis transaction. What is an arm's length basis transaction? The price has no disparity. For example, arm's length transaction means a transaction between two related parties that is conducted as if they were unrelated. That means there is no conflict of interest. You deal with the related party, you deal with the non-related party, the price, terms and conditions are same. So that means the relation is not being influenced to the transaction. Then such a transaction is called arm's length price transactions, and these type of arm's length transactions outside the scope of section 188. So this is exemption 1 and exemption 2. Any transaction arising out of M&A, that is amalgamation, mergers and acquisitions, is exempted. That is not relevant. And third one is also not relevant because that was an exemption which is given under 297 of Companies Act 1956, where a contract has been, or related party contract has already been approved. If it has already been approved, you need not want to take a new approval in the new act. It's a transition provision, it is not relevant. But this is very relevant. I advise students to please look into very carefully. Exam point of view, get a good practical question citing the value of a transaction and asking you to determine what approval you require, or if there is a restriction in the law or not. Now we are going to the approvals. As already I told, related party transactions is not been banned or prohibited in the Companies Act. Related party transaction is not been prohibited in the Companies Act. The Companies Act only puts some approval systems, and the approval system is divided into two categories. 1, 2. This is one, that is board approval, and second one is shareholder approval. For transaction, for all related party transaction, basically you have to require a board consent. Board resolution is to be passed. No circular resolution is allowed. Every related party transaction you have to take board approval. But if the list of transactions which are told goes beyond a threshold limit, goes beyond a limit which is prescribed, that you have to refer that in your home. If that limit is exceeded, then you require shareholders approval by way of a special resolution, not an ordinary resolution will be due, special resolution. So I will repeat again, approval is divided into two categories. There are prescribed limits for each transaction, like sale, purchase, intangible property transfer, etc. Each transaction you have to refer that. For every related party transactions, you have to take board approval, but for transaction above the threshold limit, for each category of transaction, you require, for example, sale of 10 crore or above. If it is so, then 10 crore or above, that is the prescribed limit. If it is in the company side, you have to go for shareholder approval at an EGM by way of a special resolution. For all transactions, irrespective of whether it is below the limit or above the limit, mandatorily you have to take board approval, and that board approval is by way of a special, regular board meeting resolution, not by way of a circular resolution. Students, now being understood the intricacies of various provisions, I told you, you have to look into the limits. You have to look into the limits under Rule 15. You have to refer to the Rule 15. You will get a list of limits. You must understand that list, because the limit is the main trigger point as to decide about whether a special resolution at the general meeting is required or not. Now it's time to conclude our class. We discussed about meaning of related party. We discussed about who is a related party. We discussed about what are the list of related party. We discussed about what are the transactions which is called as related party transaction. We discussed about which approval you require, board approval or shareholders approval. Then ultimately we are going to discuss, if you don't comply with section 188, what will be the fate of the transaction and the directors involved, office or default. 3 type of consequences are listed. One is the transaction will become voidable at the option of the board. then the director's indemnification will arise. I would like to invite you refer section 166, which speaks about duties of directors, which has now given a new clause called indemnification. That means any loss which is occurred to the company, if the directors who is in default is traceable, then the directors in default should make good of the loss, and that concept is called as indemnification. So first consequence is the transaction will become voidable, not void ab initio, voidable at the option of the board. Then director's indemnification will be required, that is called recovery of loss, and of course there will be a penalty for the same. So I conclude by saying related party transactions are not prohibited in the Companies Act. Related party transaction is only regulated by the Companies Act by way of approval systems. So that will end the show. Thank you for watching my video. More video classes are coming soon. Take care of your health. Stay at home. Thank you.